Cross-examination is a critical skill at trial. So much, in fact, that cross-examination has been referred to as the greatest engine towards finding out the truth known to civilization. It's just an opportunity in the dynamics of a trial in front of a jury where a key witness has to take the stand and they have to answer questions that are posed to them in an adversarial type setting. A good criminal defense attorney knows how to cross-examine someone, and a good criminal defense attorney has done their homework so that when they are in a position where they can cross-examine a key witness, they're able not only to poke holes in their theory of the case, but in the appropriate circumstance to destroy a witness. And I don't mean that in a mean or cruel way, but I mean that in an evidentiary way to break down the credibility of a witness, to show that what they're saying is not truthful, is something that sometimes is key towards being able to find a defendant not guilty and to show their innocence. Maybe it's a police officer on the stand who's exaggerated their role or something that they did in the case. Maybe it's catching something that a witness said in a lie and pointing out why that witness should not be believed. Maybe it's an expert witness who you're demonstrating that they're just a hired gun who will say anything that the other side paid them to say, and that their opinion is not supported or grounded in the facts nor recognized in the greater field of scientific expertise that they supposedly belong to. Those are the types of things that on cross-examination can change the entire outcome of a trial and a charge, and in the case of a client, what ultimately happens to them. Direct examination is normally the questioning that happens from a lawyer to their own witness, to someone they're calling. So we think of cross-examination, and that's normally the questioning that happens from a lawyer to a hostile or adversary witness. And it doesn't always mean that the witness is against them. A lot of times in the course of a trial, there are witnesses that are just happen to be witnesses to some part of the trial, and they're not really for or against one particular side, but they might be called by a particular party. The party who is calling them is allowed to do direct examination. There are evidentiary rules that apply to direct examination. Questions are not supposed to be leading. They're supposed to just ask things like, what happened next, and to allow that witness to describe events. On cross-examination, it's different. You're allowed to ask leading questions. You're allowed to ask questions that attempt to impeach the witness. Direct examination might be employed with a client that a criminal defense attorney is putting on the stand to testify in their own defense. In that type of setting, it's very important to work with the client ahead of time to make sure they know what to expect, to make sure they're prepared on direct examination to tell their story, to tell their version of what took place, so that the jury isn't just left with the prosecution's side of the story and their version of what happened. Closing arguments can be more than almost anything else in a case what really separates okay lawyers from really good and great lawyers. Closing argument is the opportunity where a good lawyer knows how to put together everything. They can glean all of the facts that took place in a particular trial, they can discuss it with the law, and then they can persuade the jury as to what the correct thing is to do based upon the facts and the law. That's the time where good litigators, great lawyers, can really shine. It takes work. Sometimes it takes putting together a very masterful PowerPoint that really helps visualize things for jurors that might learn or pick up things better for seeing it instead of just hearing it. But it's the opportunity to bring it all together, to persuade a jury why it's the right version of the facts supporting acquitting a defendant, finding someone not guilty. The importance behind all of this is being a good communicator. When you go into a trial, you're looking for a lawyer who knows how to advocate on your behalf, someone who is smart and can pick up on facts, things that maybe someone else might have missed, someone who's a hard worker and is prepared and puts in the work to really know the facts better than anyone else. But then in addition to that, you need someone who's a good communicator, someone who's able to put it all together, to argue to the jury, and to really persuade them to think of it not just from here's an argument, but to really think of it in the whole scheme of things, to look at from a psychological standpoint, what is a jury going to wrestle with? What are they going to decide is the key questions in this case that need to be answered? And then to spend your time as an effective advocate, as a good communicator, really addressing those points in an attempt and an effort to persuade the jury to reach a verdict that goes in favor of your client. We hear about that term courtroom presence. And in reality, when you think about courtroom presence, is that the jury is always watching. And there's a lot of subtle things that a jury can pick up on. There are folks who are smart, they're observant. A lot of times they're not individuals who have been in this kind of situation before, so they're really soaking it all in. And that's why it's very important to have a lawyer who's experienced, professional, polite, and courteous, because if a jury likes a lawyer, if they like a client, it's going to make it easier for that jury to go their way. A smart lawyer realizes the jury is seeing everything. So when they're in the courtroom, they're not like just one way when they're on the record and then a different way the rest of the time. They're always maintaining a high level of professionalism, courtroom decorum. They're treating the opposing counsel with respect and candor, and they're recognizing that their credibility is always being tested. Whether it comes to if they're making statements, if they're making arguments, they have to back it up. They're demonstrating throughout the course of the trial that they're the best prepared, that they know their facts better than the other side. And every opportunity to do that is a chance to win points with the jury throughout the course of the trial. And then hopefully at the end, when the attorney is in a position to make an appeal to the jury through closing argument about what the correct verdict is, that courtroom presence that they have paid dividends into during the course of the whole trial will then pay some of those results, because a jury will trust them. A jury will know that there's someone who has credibility who they can rely on in reaching the correct verdict.